Salomon versus Salomon and Company Limited is the heart of discussion when it comes to company is a separate legal entity. This case law in a way a starting point for discussion on corporate veil. Very interesting and very important case law, and let us try understand this case law with the help of charts. As this case law is very important and has lot of details, I have segregated the story into three major parts. I have done lot of research before I put details and figures in each place, but I can't conclude that all the data here are perfect. While studying company law, these numbers are anyhow not that critical, whereas you need to understand the context very clearly. I hope that is very clear. With that, let's get into the story. First thing first, let us try understand part A of the story. One more thing, please remember that I have made this A, B, C separation to make the case law easy as well as fit this entire story in one slide. Okay, first part goes this way. Aaron Salomon was a leather merchant and he was in the business of making leather boots or shoes as a sole proprietor. He had a wife, a daughter and 4 sons. Out of the 4 sons, 2 sons wanted to become the part of father's business. So Solomon decided to form a company by selling his proprietorship firm to the company. He sold his proprietorship firm to the Salomon and Company Limited to an exorbitant price of 38,000 pounds. The distribution of shares was in the ratio of 20,001 to Salomon and 1 each shares to his family members. So he had 20,001 shares, whereas remaining 6 subscribers had 6 shares. Salomon also was the managing director of the company and he made 2 of his sons as director of the company. Needless to say that with having almost all the shares with him, Salomon was running business as per his whims and fancies. Now let's move to the part B of the story. As company needed more funds, Salomon bought 10,000 debentures with 10% interest towards the same. He became the secured creditor and they also raised 7,000 pounds via unsecured creditors. Later, Salomon sold 5,000 debentures to Edmund. Now, Salomon and Edmund became secured creditors with 5,000 debentures each, whereas company had the liability of 7,000 pounds towards unsecured creditors. The business was making profit when Salomon was running it as a proprietor, whereas the whole scenario changed within a year of it becoming the company. The company went into losses, thus failing to pay the interest to the debentures. Finally, with all this scenario, the company went into liquidation. Now let's get into the last part of the story, that is part C. In the liquidation, they got the asset worth of 6,055 pounds, from which Edmund got paid fully for his debentures, that is 5,000 pounds. The remaining 1,055 pounds were paid to Salomon as he was the remaining secured creditor. The unsecured creditors got nothing and they went to the court asking that the company is of Salomon and hence all the others to be paid first and only if anything remains Salomon to be settled as he is the agent of the company or the company was completely of his own. The trial court and the court of appeal considered Salomon as the agent and said that the unsecured creditors to be settled first before considering Salomon himself. However, House of Lords took a different stand saying that company is a separate legal entity. With that, Salomon got 1,055 pounds. Now you might be thinking, is this the end of it? For that particular case, yes it was. But definitely not completely an end to this, because whenever this kind of legal question arises and when it becomes not so convincing for everyone, or when it looks like an unfair judgment, law always finds a new rule, and Salomon and similar other cases gave birth to a principle, that is principle of lifting of corporate veil. That we will discuss in some other class.